Now, moving on to the buyer brokerage engagement agreement, aka your BBA. Those is now the EBBEA, but we call it a BBA. So if you hear people saying, "Where's the BBA?" That's the buyer brokerage agreement or the exclusive buyer brokerage engagement agreement. And this is the document that you're going to have your buyers sign before you go out looking at properties and during your it's going to be signed. For me, it's signed during my buyer's consultation. So like the seller engagement agreement, you're going to enter your terms. So you've got your date here. There's no standard on when this needs to be start. So this is usually the date of the consultation. Okay, you're going to have your terms. And so you're going to say the terms shall continue through. Now, again, there's no standard, but we know that it's going to take us a week or two to find a property usually. It's going to take us 7 to 10 days-ish to do due diligence. Then we've got to go through the financing contingency period and then closing. So you need to allow yourself enough time to get through a transaction. So 30 days won't suffice, in my opinion. I do all of my contracts are a minimum of 90 days. So there's no definitive answer to how long. Just make sure that you give yourself enough time to work through the transaction. Again, you're going to list what type of agency your brokerage does not offer. Again, you're going to have a very detailed compensation agreement or conversation with your buyer at the time of your consultation. We're not taking buyers out or doing any work until it's clear how the brokers are going to be compensated. Again, all of these paragraphs explain what's on the preceding pages. Again, even though they've signed the identity theft and wire fraud document, they are also going to see that information here. And then here are some brochures. Like there's some additional ones with the buyer. A, B, and C's of agency. I usually don't give that one out, but I recommend that you read it. Lead-based paint. I only give that one if the home was built prior to 1978. Mold, I give every buyer the mold pamphlet. You want to make sure that you talk them off a cliff before they get there and let them know that all homes in Georgia and Florida have mold. It's a normal occurring thing, and that if they would like to get a mold inspection, that they're more than welcome to do so. But it is going to come back with some mold on it. Next up, I recommend 2025, everybody's getting a radon packet. I used to only do it if the client said they want a home with a basement. Everybody's getting one in 2025. So I'm doing that one. Protect yourself when buying real property. Everyone gets that one. Protect yourself when buying property in a community association. If they're buying, not if they're buying in an HOA, everyone's getting that one. If they're buying a condominium, they're getting what to consider when buying a home in a condominium. Protect yourself when buying a home to be constructed. So if you know they're considering new construction, you want to use that one. Flood areas, flood insurance. Again, it does not matter if they are not in a flood zone. I have an insurance license in Georgia and Florida, and I don't use it other than to help with my real estate business, but I talk to people and they say, oh no, it's not in a flood zone. That doesn't matter. Do you think all those places Helene hit were in a flood zone? They were not, and those people did not have flood insurance, and so they are literally up the creek, right? What buyers should know about short sales and distressed properties. If you start to see those, or if you're working with an investor that is working with short sale or REOs or distressed properties, you want to make sure that you give them this one. I would give this one to all of my investor clients. And then, like I said, this GARS CB, CB stands for Consumer Brochure. what to know about buying agricultural land and land near military bases, installations, and airports. You want to read that document. Okay. Um, Question in the chat says, can I use these forms for cash investing deals? Absolutely. You can give these forms to anyone. As a matter of fact, as you are creating your 36 touch plans and you want to give your database some documents like this flood insurance one, I would download it and just send it to everybody that I know. Everybody needs flood insurance, period, unless they're in the desert and we're not selling property in Las Vegas. But the way weather patterns are going now, who freaking knows? I mean, I'm not religious, but Revelation talks about weather patterns and things of that nature. I'm not super religious, but I remember Revelations and I remember all that stuff about that. So make sure that everyone gets that flood insurance packet, okay? Someone has a question? No? Okay. Any questions about the buyer brokerage agreement? It's not as detailed as the listing agreement. But any questions about that does not pertain to compensation? All right. We're going to go to our next document. All right, signature page, exactly like the other one. Again, make sure that you get your broker information and save it somewhere in your phone that you can access, what's the word I'm looking for? That it's readily available, okay? Just for context, I know you all have probably forgotten, but we are inside of the envelope where you send clients documents for signatures. So keep that in the back of your mind that that's where we are. So offer date, your offer date is going to be the day of the offer. Okay, pretty straightforward. The property address is going to be the address of the property. Make sure that you're entering the MLS number. It doesn't matter if it's Georgia MLS number or FMLS. Not and, it can be or. Your tax ID number, that's going to be obtained from the tax records. I recommend, sometimes agents, again, with data entry, will put incorrect information in the MLS. So double check that tax record number. Again, my favorite is always to attach the legal description as an exhibit. The purchase price of the property. This is just my price point for 2025. You're going to enter the purchase price. I'm muting everybody. I got a little bit of background noise. Unless you're using Remind. Yeah, I could not tell you where to find Remind or anything like that. Okay, so next up, closing costs. What does your buyer want to want the seller to contribute towards their closing costs? There is no set amount here. What you want to do with your buyer to figure out what to ask for is one, obviously, if they are short and they know that they're short on closing costs, you can ask for that amount. You want to consult with the lender to talk about, okay, how much are their closing costs going to be? And then talk to your buyer to find out how much do they have and put that there. We are moving more into a balanced and or buyer's market in certain areas. So you don't need a reason to ask for closing costs. It doesn't have to be because your client is short. you can ask for closing costs just because. Closing date and possession date, they're not always the same. So you want to put your closing date here. Do not put PD, TBD. You want to put your closing date here. If you're working with a buyer who's obtaining financing, you want to make sure that you speak to the lender. This doesn't want me to put random letters. You want to make sure that you speak to the lender and you want to say, hey, what's your time frame on closing a transaction? You want to ask the lender per the type of financing. So, Mr. Lender, how long does it take you to close an FHA transaction? Mr. Lender, how long is it going to take you to close a VA transaction? How long does it take you to close a USDA transaction? Those numbers may vary by the type of loan that the borrower is getting. So make sure that you're asking the lender about this time frame before you just put some arbitrary number on there. Some agents will put 30 days. Well, what if the lender can't close? Like a USDA deal is probably not going to close in 30 days. You're going to need more time. And so you want to make sure that you're putting a realistic closing date so that you're not having to chase down extensions, okay, after the fact. There's a question in the chat that says, if the buyer is paying cash, how do you find out how much the closing costs will be? You're going to contact the closing attorney. Because the buyer is paying cash, they don't have any loan origination fees. They don't have any lending fees. They don't have a built-in appraisal fee. They don't have any of those fees that are automatically there with your buyers who are receiving financing. Okay. So you call the closing attorney, or some closing attorneys have a portal that you can go on where their fees are listed. So their fees are already listed, and that's the seller's closing costs if they don't have a loan, what they're paying the attorney and title company, if anything. All right. Possession date, it says with possession of the property, you're going to list the possession date, and that is going to say X number of days after closing by certain time, F-219 temporary occupancy form. I don't recommend doing this because if you allow someone to move into the property before closing and it doesn't close, it's going to be a hassle to get them out of the home. Or if you are representing the buyer and the seller is saying, hey, we need to move out a week later, if they don't move out when they're supposed to, or if the home isn't clean, or if some fixtures are missing, or if the home burns down during that period, that can become messy. So I generally don't recommend doing temporary occupancy. There's a question in the chat that says, what's the usual days for USDA loans? It's going to vary by lender. And so you want to ask the lender that you work with how long they take. I generally assume 45 to 60 days. 60 is on the long end, but double check with your particular lender, the lender that the buyer is working with. Also, if your buyer is getting some type of down payment assistance, if they're getting some type of down payment assistance, it's usually going to take longer as well. So again, just make sure that you're putting a realistic closing date in there. Because if you go for an extension, the seller does not have to grant you an extension. And so you don't want your client to lose their earnest money because we put an unrealistic closing date in there. Next up, we've got the closing law firm. We have affiliate. Most of your offices have affiliate attorneys. You don't have to use those, but you're going to put the attorney's name here. You're going to put the attorney's phone number here. Make sure that you are entering the correct number to the attorney's office, because if you put it here, and they call the number that you put in the contract and it's a scammer, and they call this number to get the wiring instructions and it's going to the wrong place, you're going to be held liable for that. So make sure that you have that. All of our Keller Williams offices hold trust funds and have escrow accounts, if I'm not mistaken. But if they do not, or in some cases with distressed properties, REOs, sometimes the closing attorney will hold the earnest money. If the closing attorney is holding the earnest money, you indicate that here, and then you have to include the F-110 exhibit and the F-11 exhibit. And I've got those here for you as well. Your buyer is going to want to put some earnest money with their offer. Remember from real estate school, earnest money is customary, but it's not required. There's no set amount. In my business, I start at, no problem, Yvette. For my clients, I start by recommending that they do 1% of the sales price, but that's not a rule. That's not a law. That's just where I start. And if there's a multiple offer situation, I ask them if they can go up more. Earnest money can be paid as of the offer date. So if they have the check in hand, check or money order in hand, we don't take cash. But if they have the earnest money in hand when they're making the offer, you can put as of the offer date. That's usually not going to be the case. B is the one that's most often used, which says that the earnest money of fill in the blank amount will be, the buyer will provide that within X days of the binding agreement date. That means that the buyer is paying their earnest money after their contract is accepted. If you don't use B and you use A, if your client's contract does not get accepted, then you're going to have to request the broker to give the earnest money back. And then when you write another contract, your client's going to have to write another check, or you're going to have to resubmit the check. You generally cannot transfer earnest money from one transaction to another. It can be done, but the brokers do not like it because from a legal perspective, dealing with the Georgia Real Estate Commission, us brokers, we have to have a clear recording of all of the earnest money, and it's an administrative hassle to remove it from one transaction and attach it to another. Okay. Inspection and due diligence period. Let me just pause for a second. Does anyone have any questions on items 1 through 7? Purchase and sale, the purchase price, the closing date, law firm, holder of earnest money, or earnest money. All right, cool. We'll take another break at noon, and then we'll wrap up our final 50 minutes. So I may speed up a little bit here to make sure I get through, that I'm able to give you all a Cliff's Notes version of all the contracts. I'm spending time on this document because it's important. All right, number 8, the inspection and due diligence period. Those are not the same thing. So make sure that you are using the proper language. So the inspection period is just for an inspection, okay? And I'll tell you about some documents that you can use. So an inspection period is a period in which the buyer or borrower is able to get a homeowner's inspection, and they are able to request repairs from the seller. They can terminate their agreement if something comes up on the inspection that they do not like, or if they are not able to renegotiate the terms with the seller should something come up in the inspection. The due diligence period is a period within which the buyer can terminate the contract for any reason. If you are representing a seller, You do not have to grant the buyer a due diligence period. You can grant them an inspection period, okay? If you have questions about that, we can discuss that offline, but just know that there is a such thing as an inspection period where the buyer can only terminate the contract if something comes up in the inspection. However, most buyers are going to be using a due diligence period, and that is, like I said, it's going to be a period within which the borrower or buyer can terminate the contract for any reason. There is no set standard on due diligence period. When you're setting your due diligence period, you want to make sure that you're putting in enough time for your buyer to get a home inspection. Assuming that they're getting a home inspection, you're going to recommend that all of your clients get a homeowner's inspection. But they can do anything that they want. They can do anything that they want during this period. Option payment for due diligence period. We don't use a lot of options in Georgia real estate. It's more common in other areas like New York. For sure, they use that there. We used it a lot during COVID when there were multiple offer situations. And this is just where the buyer is paying for that option to have a due diligence period. And with this option, it says that the buyer shall pay directly to the seller an additional option money of X amount by check, ACH, or wire transfer with funds immediately available either as of the offer date or within a certain number of days after the binding agreement date. Any additional option money paid by the buyer to the seller shall or shall not be applied towards the purchase price at closing. So again, this is used in multiple offer situations where the buyer wants to provide option money to go directly to the seller to say, hey, I'm really serious about purchasing your home, so much so that I'm going to pay you money that's actually non-refundable if I default. It's going to be non-refundable, and you get to keep it. In that document, you're going to indicate whether or not, if the deal makes it to closing, whether or not it is included in if it's credited from the sales price or if the seller just gets to keep it. But again, you probably won't be working a lot with options. Next up, lead-based paint. It's the same as when you are, as the other documents, if the home is built prior to 1978. Number 10, this is where you're going to indicate how the buyer is being represented and how the seller is being represented. So here you will say buyer's broker is Keller Williams West Atlanta, Keller Williams Cityside, Keller Williams Atlanta Perimeter, Keller Williams fill in the blank, and Keller Williams West Atlanta is representing the buyer as a client, a customer, a dual agent representing the buyer and seller, or acting as a designated agent. A designated agency occurs most often when there is an unrepresented buyer interested in making an offer on a listing. So for example, if I have a listing and a buyer calls on my listing, they don't have an agent and they want to write an offer and I don't want to do dual agency, I can represent them as a customer and just type their terms, or I can designate another agent in the office to work with them, or the broker can designate another agent in the office to work with them for a fee usually. So for me, if I designate an agent to type up a contract for an unrepresented buyer, I normally give them $500. And that's taken out of my compensation paid by my seller. Okay, any questions on representation? All right, moving down to number 11, time limit of offer. Some unprofessional agents will leave this blank. Do not leave this blank. You need to let the seller know when they need to get back to you. Some agents will, what time is it? It's noon, around noon today. Some agents will say, oh, you need to get back to me before close of business today, 5 p.m. today. Give people time to review the offer. Now, if you send an offer that's like amazing and there's no reason why the seller would need to take a long time to review it, then yes, by all means, put a short acceptance period. Otherwise, for example, if I'm writing a contract on a Saturday, I'm not assuming that everyone works on the Sabbath. So I'm going to say, you can get back to me by Monday close of business or Monday by noon, or in some cases, even Tuesday. Okay. But the point and moral of the story is to give people time to review the offer with their clients. It's the weekend, so most listing agents are going to not acknowledge or address any offers until after the weekend. They want to see if they're going to get any more offers to come in. Okay. So you'll say the offer expires at 6 o'clock or 12 o'clock p.m. on Monday, January 27th. That's what I would put. Okay. So there were some questions about exhibits. And so this is the exhibit page with the offer or the purchase and sale agreement. This is not an exhaustive list. These are just the most common exhibits, and I'll give you a brief explanation of all of them. So the backup agreement contingency exhibit, you will have a listing and someone will say, or you will have a buyer and you don't get your offer isn't chosen as the offer. And so you'll say, oh, well, can my client's offer be considered as a backup? And the listing agent is going to say yes. And then you're going to say, okay, great. If you don't have this backup agreement contingency exhibit, you don't have a backup offer. It needs to be in writing. And when you have this document in writing, it says essentially, if that contract does not work out, my contract automatically comes into the next position. It automatically moves to mine. If you don't do this thing and it's just kind of like a handshake, someone else could slide another offer in there and your client can miss out. So make sure that if you are submitting a backup offer that it has that here. There's a buyer's broker compensation agreement that you can attach. If the closing attorney is holding the earnest money, you'd use that F510. The community association disclosure we've already discussed. There's a condominium resale purchase and sale exhibit. This is just entering more details on the contract for a condominium. The conventional loan, FHA, VA, USDA, those are financing contingency exhibits, and we're going to look at a few of those. And then you have your lead-based paint exhibit. We've talked about that. If it is a lease purchase, you're going to be filling out a lease purchase and sale agreement. I've not had to use those, but if you have a situation where it's a lease purchase, you can use that document. Lease purchase agreement. So when you're doing a lease purchase, you actually have to type up the lease. So you want to include that as an exhibit. When you attach that legal description that you're getting from the closing attorney or from the client by way of their deed, you're going to attach that there. And then if there's a loan assumption, you're going to do that one. So that's usually on an FHA loan. You probably won't see a lot of those. If there's no financing contingency, there's a document for that. If your client needs to sell their home before they buy this home, are y'all here with me? If they need to sell their house before they purchase, this is the document that you're going to use, the sale or lease of buyer's property contingency exhibit. If they need to rent their home out before they purchase this property, you would need to use this exhibit here, okay? The seller's property disclosure statement is here. If there's a survey, you can attach it as an exhibit. If you're doing a temporary occupancy agreement, which I strongly advise against, you would attach that here, use that one, the F219. And then if there are any other exhibits, pre-approval letter, anything, you can attach those here as other. As mentioned before, exhibits are lettered and amendments are numbered. So how I do my exhibits in terms of the order in which I put them in, I have my systems set up and it has the documents pretty much going in this order. So I took a picture of this page so I know the order that they are in on this page. And so usually this is going to include that community association exhibit as A, and I'm going to add it to the contract. I'm usually, most of my buyers are either conventional or FHA. So you're going to check that. And that's going to be your B, and so on and so forth. And as you are labeling your documents, you're going to make sure that the letter that you put here corresponds with the letter on the document. Remember when I said I don't enter my client's information on the details page? This is why. You see this stuff automatically populated. If you put it in during the documents phase or in the details page, it's going to automatically populate, and I don't want my client's information going to the listing agent. So I'm going to delete my client's email, because in transactions, people get upset, people get clever. They want to go around the agent's back, which is unethical. But in order to do anything about that, you would have to contact the commission or the Association of Realtors to file a complaint. So I'm in the business of selling houses and not filing complaints. So in 19 years, I've never filed a complaint against anyone. And so just make sure you're taking your client's information out of there if you put it in there. When you're writing an offer, we're over here working on the buy side. So all of this information would be here. It would say Tori Easterling, Keller Williams, West Atlanta, fill in the blank, okay? I recommend, is not required. If you are writing an offer, I recommend that you go ahead and fill in the seller's broker's information. This information is going to be on the listing in MLS. You want to do this, one is the professional thing to do, and it creates less work for the listing agent. I want my client's offer to get accepted. So I want to make it easy for them to accept it. Making it easy for them would include filling out this information here. Again, it's not required, but it's something that I do as a professional courtesy. It's one less thing that they don't have to do. When you submit offers on behalf of your clients, remember what I said Wednesday, you want to be like super nice. Like, we're super nice during the offer phase. Our job is to get, we're nice the whole time, but we're super nice during the offer phase. We want our client's offer to get accepted. So this is a little tip that I like to give people, because some people will say, I'm not putting their information in for them. And then when the agent gets the offer, we don't know if they use DocuSign or .loop or Remine, and they may have to download and upload and all of that stuff. So we don't want them to have to do that. So I'm going to go ahead and fill it out for them because I have access to the information and because I can. Any questions on the purchase and sale agreement, the F-201, aka the offer? All right, cool beans. We are at our second break. So this is a Tory tidbit. This document is called the Reminder of Important Dates in Purchase and Sale Agreement. It is the F-264. Once you are under contract, you'll use this document once you're under contract. And this is a one-pager that you can print out and carry with you such that you can access any information that you need at your fingertips. It should also be the first document in your room if possible. But you can put the buyers, the sellers, the agents, the binding agreement date, the earnest money, due diligence period, appraisal contingency period, the financing contingency period, the source of funds, the deadline for documents to get to the lender and the attorney, closing date, possession date, any other dates and deadlines. Down here, you can send copies to and enter the contact information for the buyer, the lender, the sellers, or the closing attorney. So I just like this document. It's a one pager with all the information that you may need at any given time for your transaction versus having to go into DocuSign, pulling up your contract and looking through the contract to find out when these dates are, going to the calendar, counting the days to see when the contingency periods end. If you use a contract to close or transaction coordinator, they may not all use this form. You can give them this form and tell them to make sure that they include this form. Your clients appreciate this as well. You can give that to them. Okay. The next document is the backup contingency agreement. So we talked about that. So there's a copy of that in there for you all. The FHA loan exhibit, this is the document that you will be using if your client is getting an FHA loan. We're not going to go into the financing exhibits verbatim. I may do a contracts class just on financing contingency exhibits for West Atlanta. If you all are in this class and you're not with West Atlanta, I normally have you all in a list and I'll invite you all. For the most part, if you attend one of my classes, you'll get invited to all of them because I don't, I think that you should be able to go. So unless it's a class that I'm being, never mind, that's too much information. So I'll let y'all know when/if I do this class or if I do a video and post it, I'll send it to you all to watch. So this is the FHA exhibit. A few points on this. Under the approved lender section, you want to leave this field blank if possible. If you put in a lender here, that means your client is 100% absolutely getting along from that lender. So if something happens in your transaction where you need to switch lenders, then if you put a specific lender here, then you're going to have to go back to the listing agent and get an amendment to accept that new lender into the equation. You're also going to have to disclose, like that's going to let the seller know and alert them to the fact that, oh, there are some issues with the lending and they may start to feel uneasy. So if you read this number 2, it says buyer may apply for approval for the loan with any mortgage lender, mortgage broker, or mortgage loan originator licensed to do business in Georgia. If any lender is identified below, the buyer shall apply for approval. If any lender is identified below as the approved lender, buyer shall apply for approval of loan with at least one such approved lender. Nothing herein shall require the buyer to obtain financing from an approved lender herein. So it's not going to require them to do that, but if you change it, you're going to have to get an amendment. Okay. Financing contingency, important to note with an FHA loan, this amendatory clause here, you're going to get this from the lender as a separate document, but it's here as well. You're going to put the minimum appraised value here, which is usually the same as the sales price. There is no appraisal contingency explicitly stated in an FHA exhibit because the FHA amendatory clause covers the appraisal all the way through closing. So if the home does not appraise, the buyer is not required to move forward, regardless of what another, like a listing agent, may put in the contract as a special exhibit or special stipulation. The amendatory clause is going to cover them. So if the property does not appraise, your buyer is not going to be required to move forward. Also important to note, FHA loan appraisals, they last for 6 months, which means if you're working with an FHA buyer, and that FHA buyer, the appraisal comes in low, and your client, the seller says, no, we're not going to reduce the price. And so you all terminate the contract, your buyer gets their earnest money back, and then the seller puts the home back on the market. If another buyer comes along and they have an FHA contract or an FHA financing, the lender is not going to order another appraisal. They're going to use the same appraisal that was already ordered from previous orders, and they're going to do that for 6 months. Okay. FHA loans are given a special number. They're given a loan number or a case ID number. I forget what they call it, but it's given a number for the property, for that specific property. So when you're negotiating, if the seller does not want to move forward because an FHA appraisal came in low, then just let them know that's fine. But if another FHA buyer comes along, then you're still going to have to sell for this price. So, or you're going to have to choose not to work with an FHA buyer. And some sellers do choose to go that route. Some condominium buildings don't allow FHA loans. And that's one of the reasons why. Here's the conventional loan exhibit. Nothing super exciting here. Conventional loans are not government backed. If you're using a conventional loan, there's a paragraph here about the appraisal contingency. Again, I want you all to read through these documents over the weekend. Print them out if possible or upload them to the tablet. Make highlights on them and or write down any questions and bring them to class Wednesday if there's something that isn't clear. Here is your VA contingency exhibit. Same thing, nothing to see here. Up here, you're going to enter the amount of the loan. Of course, with VA, that number is always going to be 100% because there's no down payment required with VA loans. With FHA loans, the down payment amount is usually 3.5%. However, be careful with that. There are different types of FHA loans, so it's not always going to be the same with FHA like it is with VA. Again, read through the contract. You're going to have the VA funding fee information here. Write this down in your notes. VA loans require a termite letter. A Georgia wood infestation report is required. On this VA loan exhibit, you're going to enter who's responsible for paying it. But you have to have a termite letter with any VA loan.
And Tori, does that also apply for new construction homes?
If it's a VA loan, yes.
Okay, thank you.
You're welcome. I recommend getting termite inspections. There is a company called Skyline Pest Solutions. Generally speaking, if you call them and let them know that you are a Keller Williams agent, they will usually do your inspection at no cost. The inspection, they won't issue the letter at no cost, but they'll do the inspection at no cost.
And what is the name of that company?
Skyline Pest Solutions.
Thank you.
And just let them know that you are a Keller Williams agent. Okay. All right. So lastly, you have your USDA-RD loan exhibit. Your USDA loans, if you're not familiar with those, that's going to be for homes that are in, y'all know I can't say that R word. Rural areas. Natasha's like, what word? Rural. They're going to be, it's going to be used for properties in rural areas. And so make sure that you learn about USDA loans. You may not realize which areas are considered rural. So rural. So if you're working out in like Douglas County and Carroll County, some of those areas may qualify for USDA loans. All right. That's your USDA loan exhibit. I'm actually going to touch up on that one too myself. And then if there's no financing, you've got the all cash purchase here. So sometimes people will not use any type of financing contingency agreement if the client is paying cash. If they're paying cash, you can use this document here. If someone is paying cash, they have the option to get an appraisal or not, and you're going to indicate that on this document. This is one of the reasons why you want to make sure you don't omit this document, because if you don't use it and the buyer goes out and gets an appraisal and said that they want to cancel the contract because the property didn't appraise for their sales price, then you could have an issue on your hand if you're the agent and you did not advise. If you're representing the buyer and you didn't, you didn't advise, you didn't include that document in the contract, it could be an issue for you. Or if you're representing the seller, it could create some issues for you because you're like, you didn't say anything about an appraisal. And then now you've got a problem. Amendment to address concerns with properties, or the ATAC. So we use a lot of acronyms. Which one of you texted me and used an acronym? I was like, I don't even know what the acronym is. So we use a lot of acronyms. This is one that you'll see a lot. They'll say, did you send the ATAC, the amendment to address concerns with the property? So after your due diligence period, if something comes up in the inspection, or if your buyer wants the seller to remedy anything from that inspection, this is going to be the document that you use. Okay. So you're going to remember, you're going to state the who, what, when, where, why, how, and all of that. Most of your inspectors now have some type of a function in their portal to where you can check the items on the inspection report that you want repaired, and it will create a document similar to this, but it's not a GAR document. You can copy and paste from that, or you can click, where is it? Is there a check? This is the 2025 form. There's usually a check where you can, oh, there we go, additional pages. So if you've got additional pages, you can check that there, or you can type it in the special steps that the document is attached, okay? So this is the document that you use. Here it says, if the parties agree on these repairs, does that automatically terminate the buyer's due diligence period? So let's say you get your inspection the next day after your offer is submitted, but you have a 10-day due diligence period. When you get your inspection back, you send it over to the seller, your ATAC over to the seller. The seller says, sure, we're going to fix all of that. And they sign it right away. And now you've got that covered. This paragraph or this sentence here says, okay, if the seller agrees, do you still get those 9 days for your due diligence period, or does that due diligence period still get to play itself out? So that's what this right here means. It shall or shall not terminate. Okay. Any questions on the ATAC?
Yes, what's the best practice on that? Should it terminate or shouldn't it terminate?
If you're representing the seller, you want it to say shall. So when I represent the seller and it comes back and it says shall not terminate, I'm gonna be like, well, what's the problem? What else do they need to figure out? I want to know what other issues are they trying to do due diligence on. So I don't want it, I don't want it to continue if I'm the seller's agent. If I'm representing the buyer, then I want it to last that whole period, because something may come up and I want my client to be able to get out of the contract. When they, I want them to be able to get out of the contract if something comes up within that 10 days, even though we've agreed to the repairs. Okay.
Okay, so represent the seller, you want to check shall, and represent the buyer shall not.
Correct. Now,
Okay.
remember, this document is only going to be coming from the buyer because the buyer is getting the inspection. So as the seller, you're not filling out this form. You just want to look at it as the seller's agent to make sure that it says shall. If it says shall not, you're going to pick up the phone and you're going to not email, you're going to pick up the phone and call the listing agent, call the buyer's agent and say, hey, I noticed that you don't want the due diligence period to terminate. Is there anything else that you all are concerned about, or is there anything else that you're going to be inspecting or doing more due diligence on? And the agent's going to say, oh, no, I just always put it like that. And you say, do you mind going ahead and marking shall and sending that back over? And then, in that conversation, you'll find out if they're looking for something else or not. It's not a problem. You just need to have a conversation about why y'all need more time.
Got
Because
it.
if my client has agreed to do all of these repairs, that's going to cost my client money. And then you're still in your due diligence period. What if you come back and ask for something else? Like, no, we've already agreed on this. So we're going to end that period. Okay. All right. Next up. There was something I was about to say. Moving right along, you have the agreement where the attorney is going to be holding the earnest money. That's going to be your form F511. That ATAC was F704. With the holder of earnest money documents, the attorney, you're going to need both of these forms. It's not one or the other. You're going to need the F10 and F11. And one of them, the attorney has to sign stating that they agree to hold the earnest money. Not everybody wants to hold trust funds. Okay. So notice to unilaterally extend the closing date for 8 days. So in the state of Georgia, no matter what the contract says in terms of the closing date, either the buyer or seller is able to unilaterally, meaning they don't need the other side's approval or agreement, they can unilaterally unilaterally extend the closing date. Some agents feel that you can do this for any reason. My client doesn't want to close today, so I can extend for 8 days. You cannot extend for any reason. You can only extend for one of these two reasons. Either the seller cannot satisfy valid title objections, excluding liens, judgments, and deeds to secure debt that can be satisfied through the payment of money or by bonding off the same, and by title objections which do not prevent seller from conveying good marketable title. All that's saying is if the title work isn't back yet, so if the closing attorney does not have all of the pertinent information back and everything hasn't been worked out between the parties as it pertains to title, then we can delay the closing for 8 days while we work that out. Okay. Lenders, you've got to stay on top of lenders. I gave you all those checklists on Wednesday and last week. Make sure it's not your job to pull title, but make sure that you're asking the attorney if they've pulled title or sent the request to pull title. I think a good time to do that is when due diligence ends. Once due diligence ends, like everything needs to be in motion. If you want to drag a little bit while due diligence is going on because you're not sure if the transaction is going to proceed, that's fine. But after due diligence, you need to be on top of the lender, on top of the, not the inspector, inspector's done, on top of the lender, on top of the closing attorney to make sure that they're doing everything that they are supposed to do. The buyer's mortgage lender or closing attorney cannot fulfill their respective obligations by the date of closing. So here again, the lender, and it says as no fault of the buyer. So again, if the lender or the closing attorney, if they're not ready to close, then the contract can be unilaterally extended for 8 days. Any questions on that? So it's not for any random reason. Also, a contract can be unilaterally terminated. So if the buyer during their due diligence period, they find something that they don't like, the parties can agree to terminate the contract. But if you're terminating during due diligence, you're more often than not, you're going to be using the unilateral. So it says the buyer, you can do buyer or seller. The buyer or seller will terminate the agreement. And here you have on A, it says the buyer's right to terminate during due diligence. So during due diligence, your buyer decides to terminate. You're going to use this unilateral notice to terminate the purchase and sale agreement and proposed disbursement of earnest money. It's going to initially be up to the broker on how the earnest money is dispersed. And this document is the F-522. Okay. It's also giving you the options to say failure of the following contingency to which the agreement is subject to. So let's say if the financing contingency agreement or anything like that, it wasn't followed, you can terminate unilaterally for that. Or if there is a default by either party, you can do it for that. Or on D, you can put in any other lawful reason. So that's your unilateral termination. You're going to propose who you want the earnest money to go back to. If you're representing the buyer, you're going to propose that they get their earnest money back. You're going to want to put their name, and you're going to want to put the address to send the funds to. Or if they're picking it up from the office, you're going to put the office address. Okay, so this is just the proposal. The broker ultimately gets to decide how the earnest money is dispersed. If the parties are not in agreement with that, that's a whole different conversation. There's a process that the broker and MCAs at Keller Williams know how to navigate that, okay? So even though this is a unilateral termination, you're going to send this over to the other side and they sign. If they don't sign this earnest money part, that's where it goes into the broker sending out a letter, what's called a 10-day letter for people to plead their case. And then that could go all the way to court and arbitration on what happens with the earnest money. Next up, I think this is the last document, the pay at close request. If you want your check to be cut at closing, you need to submit this. This is the West Atlanta form. Make sure that you are using your office's form. I'm going to send you all these documents, but make sure you're using the form that's specific to your office. You want to put the binding date, whether it's a listing, buyer, sale. You're going to put all of the required information here. Okay, the attorney, are there any team splits? Are there any referrals? If there is a referral, you're going to need to upload the W-9 of the referral agent's broker. You're going to need to upload that into your command. And then if it's approved, they are going to provide you with what's called a DA, and they're going to provide you with the D as in dog, A, disbursement authorization. They're going to provide you with that before closing. In order to get paid at closing, you have to pick up that DA from the office or get the MCA to email it to you or email it to the closing attorney so that the closing attorney knows that they are to issue your check at closing. Okay. And then this is just another affiliate business disclosure. So what happens if you get to the end and you realize you forgot a document? Okay. I am going to click send later. Nope, I'm not going to do that. This will automatically send it later, but I'm going to go back I'm going to save and close. Remember, we're in the envelope. I'm going to save and close. I wonder if I can add it to we're going to learn together today. I forgot to add a document for you all. The document is called the Instructions to the Closing Attorney. And you'll hear that referred to as the commission agreement, instruction to closing attorney, or the F-255. Okay, so I forgot to add that document for you all. That document is going to tell you all, or tell the closing attorney, who's getting paid and how. That's called the commission agreement. So I did it quickly, but I just went back to the documents page. I added as a document, and now I'm going back into the envelope that I saved, and I'm going to see if that document is there. That document's not there, but I'm going to click this drop down. I'm going to add room documents, and I'm going to go grab that document. Instructions to closing attorney, and then I'm going to add that document to my envelope. Okay, so now that document is in our envelope. It added all these fields again. Or can I do this? Let's see. And that's taking us back to our documents. Okay. Because we saved it, everything is still going to be there. I'm going to go directly to that document. So this is the instructions to the closing attorney, or the F as in Frank 255. It's stating here how compensation is taken care of. So it says compensation paid by seller to seller's broker, compensation shared by seller's broker and buyer's broker, compensation paid by seller to buyer's broker, compensation paid by buyer to buyer's broker. Okay. So that's telling the closing attorney how you're getting paid and whose money to take it from. Is it coming from the seller, the buyer, the seller's broker, or the buyer's broker? If there are any additional directions on money for the closing attorney, you're going to indicate that here. So for example, let's say you told your client that you're going to pay for their home warranty. You could put that here if I'm representing the seller, or you can put that here. If you are getting any rebates, so I know, for example, one of the home warranty companies that I use, they do like a $25 thing. So that would go here. They used to. I haven't done it in a long time. But that's where you put any rebates that you're receiving. And then if you all can see, I typed that information in special stipulations. It came over here. And then the brokers are going to sign this. Only the brokers are signing this. They're only signing the document, the buyer and seller. This is new. The buyer and seller are only signing it if they're paying, So if the buyer isn't paying, then only the seller is going to sign. And this is going to tell the closing attorney how to pay you at closing, okay? When you send, and then you send, and when you send it, it's going to go to your client for them to sign. When they sign, it's going to come back to you. Okay, it's going to come back to you when they sign. And it's also going to email them a copy of what they signed. So we're supposed to provide our clients with a copy of everything that they signed. And so now I'm going to download the packet and upload it so that you all have all of these documents. I uploaded them earlier individually, but if you'd like, well, let me ask you all, would it be, y'all have the documents individually? Is it helpful for you all to have them in one document, like as a training packet? Do y'all need that? Okay.